All right, let's dive right in. Today, we're talking about one of the most exciting and frankly crucial steps for any entrepreneur out there, how you take a brilliant idea and turn it into a real, actual, legal company. This is the magic step that turns a dream into something that can sign deals, own property, and maybe even change the world. So let's get to it.
You know, when you think about it, every huge brand you can name, whether it's a massive tech company or just your favorite local coffee shop, started in the exact same place, as an idea. But an idea, well, it's just an idea until you give it its own legal identity. And today, we are breaking down the blueprint for exactly how that happens.
So here's our game plan. We're going to start with the spark. Who is the person that actually gets the ball rolling? Then we'll get into their duties and, more importantly, the dangers they face, especially when making early deals. After that, we'll walk through the official nuts and bolts of registration. And finally, we'll look at the two big paths you can take, going public versus staying private.
Okay, first things first, the spark. Let's talk about the person, the key player, who actually kicks this whole thing off.
In legal terms, this person is called a promoter. And no, it's not about throwing parties or hyping things up. It's a very specific role. Think of them as the architect of the new company. They're the one negotiating those first contracts, finding the first directors, and trying to get the initial funding, all before the company's even technically, legally born. But here's the thing, this role isn't all about vision and hustle. It actually comes with some pretty serious legal responsibilities. So let's dig into what a promoter's duties are and the dangers that come along with them.
Okay, at the absolute core of a promoter's role is something called a fiduciary duty. The easiest way to think about this is that you are the legal guardian for a company that doesn't exist yet. That means you have to act in its best interests, not your own. No secret backroom deals, no hidden profits. If you have a personal stake in a transaction, you have to be completely transparent about it. The law basically puts you in this position of ultimate trust.
So, for instance, let's say you buy a building for £100,000. You can't just turn around and sell it to the company you're forming for $200,000 without telling everyone involved exactly what you're doing. That is a textbook breach of your duty. If that comes out later, the company can actually sue you to get that secret $100,000 profit back. Seriously, the law has zero patience for that kind of self-dealing.
And that brings us to one of the absolute trickiest parts of starting up, signing contracts before the company is even officially on the books. I mean, what happens when you're moving fast, you need to lock down an office or order some crucial supplies, but you're doing it for a company that legally is still just an idea?
So let's make this real. Imagine you, as the promoter, find the perfect office space. You sign a 1-year lease, and on the dotted line you write "for and on behalf of Future Tech Limited." But then, something goes wrong. The registration hits a snag and the company never gets formed. Who's on the hook for a year's worth of rent? You can bet the landlord is going to come knocking, but on whose door? The answer, and you need to hear this, is pretty stark. You, the promoter, are personally liable. The contract is with you. You simply cannot legally bind a company that doesn't exist yet. And here's the real kicker. Even once the company is formed, it can't just say, okay, we'll take that contract now. The law sees the brand new company as a separate person that wasn't around for the original deal. The liability, it stays right on your shoulders.
So how in the world do you get off the hook? Well, there's a specific legal process called novation. It's actually pretty straightforward. Once the company legally exists, it simply creates a brand new identical contract with the other party, in our example, the landlord. This new contract completely replaces the old one, and just like that, the promoter is freed from all personal liability. It's a total clean slate.
Phew. Okay, so now that we've navigated those early risks, it's time to actually make this company real. Let's look at the official blueprint for getting registered.
Really, it all comes down to 3 key documents. First up, you've got the main application form, IN01. This has all the basics, the name, the directors, the address, all that stuff. Second, there's the Memorandum of Association, which is really just a formal statement from the first shareholders saying, yep, we want to form a company. And third, and this one is so important, you have the Articles of Association. This is the company's internal constitution. Its rulebook for how everything from board meetings to shareholder rights is going to work.
So you get all your paperwork in, company's house gives it the green light, and then they issue the certificate of incorporation. This is it. This is the company's official birth certificate. And this moment is huge because the company becomes what's known as a separate legal person. That means it can own property, it can enter into contracts, it can even sue or be sued all in its own name, completely separate from the people who founded it.
Okay, so the company is born. But now, what kind of company is it? This leads us to a really crucial choice every founder has to make, taking the path of a private company or a public one. And trust me, the differences here are pretty significant. A private company, an LTD, that's the simpler, way more common option. You can get started with just one director. You don't even need a formal company secretary anymore. But a public company, a PLC, that's a whole different league. You need at least 2 directors, a qualified company secretary is mandatory, and you can't even start trading until you get a whole separate trading certificate. It is a much, much more regulated world.
And honestly, the biggest difference often just comes down to cash. A public company has to have at least 50,000 pounds of share capital issued, and a quarter of that, 12,500 pounds, has to be paid up in the bank from day one. A private company, it has no minimum. You could literally start one with a single 1-pound share.
All right, let's lock in the key takeaways from all this. First, a promoter has that all-important fiduciary duty. They have to act in the company's best interest. Second, remember that promoters are personally on the hook for any contracts they sign before the company exists. Third, getting registered boils down to key documents, especially that IN01 form and the Articles of Association. And finally, public companies play by a much stricter set of rules than private ones.
So there you have it. That is the legal roadmap from a simple idea to a fully registered company. Following these steps gets you to the starting line. But the question I want to leave you with is this. Knowing the rules to create a company is one thing. But are you really prepared for all the responsibilities that begin the second it's born? Because really, that's where the journey truly starts.